In a big win for the Modi government, the Supreme Court today upheld the abrogation of Article 370. I'm Barkha Dutt, you're with the Mojo story. Our continued coverage of the ramifications of this big verdict today from the Supreme Court continues. A constitutional bench headed by the Chief Justice of India, Dhananjay Chandrachud, has ruled unanimously that the abrogation of 370, a contentious decision taken by the Modi government, is legally and constitutionally sound. The judgment has argued that Article 370 is a temporary and transitory provision of the Constitution. The petitioners had argued that ever since the Jammu and Kashmir Constituent Assembly was dissolved in 1957, Article 370 came to be a permanent feature of the Constitution. The Supreme Court did not agree. One of the judges, Justice Sanjay Kaul, asked for a Truth and Reconciliation Commission that would look into quote unquote violations by both state and non state actors. But whether this individual judgment will be binding, we do not know. Otherwise, the verdict held that the consent of the State Legislative Assembly was not required before the abrogation of 370. To talk about this judgment and its legal observations, we're joined now by a very special newsmaker, India's top jurist and constitutional expert, Fali Nariman. Mr. Nariman, it's always a pleasure and an honor to be speaking with you. What did you make of this verdict that has come unanimously, sir, from the Supreme Court?
Let me make it very clear that as a practicing advocate, at least an advocate who was practicing before I reached 94 years of age, it is not my job to say whether the judgment is correct or incorrect, for the simple reason that the Constitution says that whatever law is declared by the Supreme Court is binding on every person in the country. That includes all of us as well. So therefore, I can only tell you what I believed was the legal position before the judgment. And I'm not concerned with what it was argued. I was not present when anything was argued in the court. My own view was, and I may be right, I may be wrong, that Article 370, whether temporary or not temporary, that's what the marginal note says. The main section doesn't say so. Is a provision of the Constitution. And Article 368, which is the amendment provision, expressly says that any provision of the Constitution may be amended by the Parliament with the requisite majority. And if that is not done, then, and if it is done by a notification, that, in my view, would be totally invalid. That was my view. Therefore, I don't know whether this point was taken, not taken, but whatever it was, I only give you what I believe should have been the correct position.
So if I may interrupt only to understand that further, do you believe the manner in which the abrogation took place, later upheld by Parliament, was legally sound?
It's not upheld by Parliament. No, please. That's not my point. I'm saying that 370 was in the Constitution. It was legally passed. I have no difficulty about it. My point is only this, that if you wish to abrogate a provision of the Constitution after it is inserted in the Constitution, the only method known to the law to the Constitution is by an amendment of the Constitution. That is, it had to go through Parliament. It couldn't be done by a notification. That's the point. It couldn't be done by a presidential notification. That's all. That's the main point. I don't know why that. Yeah.
Yes, no, so therefore, in your opinion, in your legal opinion, the way the abrogation took place was wrong.
The way the
amendment took place was wrong.
Yes, of course. They had no power to amend any part of it. Much less did they have power. Did the president have power to amend Article 367? Who gave him that power? they added clause 4 to Article 367 in order to get rid of the proviso to Article 370, clause 3. I hope you have followed what clause it says. Article 370, clause 3. It says provided that. Have you got that? Just see, you don't have it. I'll read it to you. 370, clause 3 expressly says, where's the damn thing? Hello?
Yes, sir, please go ahead. We're listening to you. We're listening to you.
Yes. I just want to show you. Please,
Yes.
370, clause 3. Yes, that's right. Clause 3 says that notwithstanding anything in the foregoing provisions of this article, the President may, by public notification, declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as he may specify. Now, it is said that this is what the President did in 2019. Now, this could well have been done if you don't read the proviso. The proviso says, provided that the recommendation of the Constituent Assembly of the state referred to in clause 2, that is the state of Jammu and Kashmir, shall be necessary before the President issues such a notification. Now, no such recommendation was forthcoming for the simple reason that there was no Constituent Assembly of the state and there was no constitution of the state of Jammu and Kashmir. But that made it no clear. That made no difference. The proviso then should have been deleted by a constitutional amendment.
But can I ask you a question? I just pulled out my notes because Parliament did approve the resolution to repeal Article 370 on the 6th of August 2019, right? So even if the initial decision was by a notification, Parliament did approve that resolution. And that is what I was trying to understand.
That's not the point, Barkha. We are now concerned with constitutional law. And constitutional law requires it can only be by an amendment to the constitution in the manner mentioned in 368 with all the requisite voting, etc., etc. It can't be done because somebody approves of something. Assuming Parliament by a resolution approved of it. Approval means by a resolution, not by a law. I hope I've made myself clear.
So in your opinion, the original abrogation in the manner that it was done was unconstitutional?
Totally. That was my view. I now stand corrected because of the judgment. And I have to. But that makes no difference. Therefore, as a lawyer, I can't say that Supreme Court is wrong or Supreme Court is right. I have no authority to say either of them.
But you clearly disagree.
I must tell you one thing. No lawyer has that authority. Please, you must, when you question all these lawyers and ask them their opinion, no lawyer is empowered to say that this decision is wrong or that this decision is right. He can only say what was his view before the decision came into existence. Whether it was argued or not argued, I am not concerned with. And no one is concerned with.
I want to understand something. One can disagree with the Supreme Court, right? One can disagree, accept a verdict, but not agree with it, correct?
Before you like that. But I, as a lawyer, I can't disagree. I'm sorry. I don't disagree with Supreme Court judgments because I'm a lawyer. I have the discipline of a lawyer. Therefore, Article 141 says the law declared by the Supreme Court is binding on everybody. It's binding on you. It's binding on me. You may say I'm not a lawyer, so I don't care a damn. But I am a lawyer, so I do care a damn. So that's not the point. The point is not whether the judgment is right or wrong. The point is what is, according to somebody or somebody else, the true interpretation. This is my interpretation.
So I want to understand this properly. What you are saying is now that the Supreme Court verdict has come, you are not going to agree or disagree with it. But looking back at the original manner in which this change was brought about, you do not believe it followed the procedure needed for a constitutional amendment.
Absolutely correct. That's my point, and that should be every advocate's point whom you can ask. I don't like advocates saying this decision is wrong. You have no business to say this decision is wrong. We have no business to say this because Article 141 bars us. It says everything declared by the Supreme Court is binding on everybody, on all courts in the country, and everybody concerned, on you and me, etc. So we can express our view. That's all. It's only a view. Then this is my view. Therefore, and besides this, you see, there was no power given to the president to issue any notification adding clause 4 to Article 367 also, because that was a very important. Just see 367. Where's 367? Sharma, come here, I say, instead of standing there. 367.
367.
Yeah.
367. Yeah. 367 4. Yeah, bottom में 4.
367, and they added 4. Now that was added by not by an amendment. It was added by the presidential notification, which nobody has empowered him to do.
One of the things, Mr. Nariman, one of the things the court said today was that the petitioners had not challenged the powers of the president, and so therefore the court did not comment on it.
And you please ask all these gentlemen and ladies who appeared for the petitioners. I don't know whether it was challenged.
Okay, let me understand this from you.
You see, I am giving you my view on this. That's all. I'm not giving anybody else's view.
So carry on. You were wanting to make you were looking through your papers to make a point.
367 4 was added by that notification by the president. And it said, for the purposes of this constitution, Article 367, there shall be added the following clause. Now, clause D, to proviso in clause 3 of Article 370, the expression constituent assembly of the state referred to in clause 2 shall read legislative assembly of the state. Now, this is nothing but an amendment of the constitution. How can he do it by a notification? He has to do it by a law. Under Article
so basically, a constitutional amendment cannot be done via a notification and a parliament approval unless it is passed as a constitutional amendment.
Absolutely, with the requisite majority. That's all. Now, I'm not on the politics of it. Whether they had the majority, they did not have the majority. I'm assuming if they had, they should have done it. If they didn't have it, it's bad luck.
So this change needed to be brought in as a formal constitutional amendment.
That's right. Or a constitutional amendment should have deleted clause 3 of Article 370. That's the other alternative. It could have done that.
So either the law that required this amendment should have been changed, or the law should have been passed as a constitutional amendment formally, right? Am I understanding you correctly?
Yeah. Yes, correct. That's my view. That was my view. That's all. I'm now bound by this view, as everybody else is bound. Whoever argues with you or whom you interview, they are all bound. They may not accept it, but that doesn't matter. There's no question of accepting a judgment and not accepting a judgment. You may comment on it, but comment on it can only be in the form of saying that this was my view, not that it is my view. It can't be my view.
So you're saying before the verdict, this was your view. Now that the verdict has come, you accept the verdict.
I don't accept, I don't reject. Why should I reject or accept? I'm not there to accept or reject. Who am I? I'm just a citizen of the country. We have to accept.
You're India's top lawyer, sir. You're India's top lawyer.
It doesn't matter whether I'm a top lawyer or a bottom lawyer. It makes no difference. I'm a lawyer, yeah, so what? A lot of lawyers. The good lawyers, bad lawyers, passable lawyers, all sorts of lawyers. There are good judges, bad judges, passable judges as well. So it makes no difference.
Now, I want to ask you one other thing, and I'm going to summarize what you've just said. You have said that before this verdict, you believed that no law could have been amended in this manner via notification and a parliament approval.
Please, if you don't mind.
Yes.
My point is, that the President of India did not have the necessary authority under the Constitution to issue a notification as he did, for the reason that under clause 3 of Article 370, this power accrued to him only when, give me 370, I can't see this damn 370 here. Only when the recommendation of the Constituent Assembly of the state referred to in clause 2 was given. Because the proviso to clause 3 of 370 says it shall be necessary. Now, if you say the Constituent Assembly of the state was not there, the Constitution was also not there, then what should have been done is delete the proviso. And how is the proviso to 3 to be deleted? Only by a constitutional amendment. Once again.
So either may I clarify for the last time? I'm sorry, because I just want to be correct. You're saying that the president did not have the authority to bring this change via a notification, which was subsequently approved by Parliament. Either this needed to be formally passed as a constitutional amendment, which the BJP may have well had the numbers for, or there should have been a change in the law that requires that constitutional amendment. Am I correct?
Which change in which law? No.
You're saying that either there should have been a formal constitutional amendment, not a change via notification from the president and approval from the Parliament. That was not enough.
Yes,
that was insufficient.
Yes, correct. Because Article 368 says any provision of the Constitution is to be amended in the manner mentioned in 368 and in no other manner. And these words, notwithstanding anything in this Constitution at the beginning of Article 370, which may be relied upon, gets watered down because if you see clause 3, it says notwithstanding anything in the foregoing provisions of this article. So that notwithstanding is deleted virtually.
But sir, I'm still confused because the Lok Sabha did pass the Jammu and Kashmir reorganizational bill with 370 votes in favor and 70 against. So I'm confused because both houses of Parliament did give its approval formally to this bill.
I'm not on the bill. The bill has nothing to do with it.
You're saying the original notification by the president was the problem.
No. You just see, please, if you don't mind, Barkha. There is some confusion. You see, the power of the president under clause 3 of Article 370, which is very strongly relied upon by the court, says that the president may by public notification declare this article shall cease to be operative. Got it?
Yes.
Therefore, the president did so declare. Right? Now, the president could only so declare
by the recommendation
if the proviso was applied, namely that the recommendation of the Constituent Assembly of the state shall be necessary before the president issues such a notice. Was it there? It wasn't there for the simple reason that there was no Constituent Assembly and there was no Constitution of Jammu and Kashmir. Right? If that was so, then my point is that the proviso should have been first deleted. In order that the president acquired the power to issue a notification without complying with the proviso. That's my point.
Understood. So you're saying that the way the presidential notification came...
Bill, yeah. It has
so
nothing
you're
to
saying...
do with the reorganization bill. The reorganization bill only made this state into a union territory. Whether that was right or wrong is a separate question.
They use the presidential power to knock off this recommendation of this.
You see, the president only has the power if there is a recommendation of some other authority.
So
now that authority was not existing. That we understand that. If that authority was not existing, you had to delete the proviso. Now, if you just read it without the proviso, if you delete this provision, it says President has full authority to declare the article shall cease to be operative. Then the President has full authority.
This is the honest case. Straight.
You have only to delete the proviso. That's all. But that wasn't deleted.
You believe the president did not have the authority to issue the notification, and in that first step, it was unconstitutional.
As he did.
To amend 267. 367.
Because secondly, the president also,
with this power,
an exercise of this power, also purported to add a clause in Article 367, which is clause 4. I don't know if you have got clause 4. If you have got a constitution book on the constitution, you'll find that in the footnote.
It came on 5th of August, 1 day before.
It came on 5th of August.
So amending this.
Amending, to Article 367 shall be added the following clause. So the purposes of this constitution as it applies. Now, this is not done by an amendment to the constitution. This is done again by a notification, which is again invalid. There is no such thing.
Amending the constitution.
It's an amendment to the constitution. How can you add a clause by a notification? Who authorizes you?
So at the very first step, the presidential notification is where you think the unconstitutionality lay.
Yeah, absolutely correct. Absolutely.
So the unconstitutionality is in the presidential notification, according to you.
And it makes no difference whether this was a transitory provision or it was a temporary provision, because Article 368 says any provision, which includes the temporary provision. So it makes no difference. What difference does it make? It was added in the constitution. It has to be taken away by an amendment. You can take it away. Who's stopping you? If you have the requisite majority, take it away.
So the proviso was a safety, the recommendation of the
But then I don't know whether this was argued, not argued. I'm not trying to be too clever. That's not my point. You ask me my opinion. I'm giving you what I believe to be the correct position in law.
Okay. I think I finally properly understood your position, but can I ask you one more question, which strikes me as confusing? The special status to Jammu and Kashmir is now gone. The Supreme Court has upheld that decision. But there are plenty of other parts of the country, in Article 371, that continue to enjoy that special status. Is that not a contradiction in law?
And that's all right. That's perfectly all right. I don't see anything wrong in that. Yeah, a lot of them. In fact, Sikkim, if you will, I don't know whether you know, Sikkim was added. You'll find one of the sub-articles says 371 blank, what Q or BP or something, which relates to Sikkim. It gives you special powers for Sikkim, which are not there for any other state. This whole chapter is like that. The whole temporary and...
But how do you legally explain taking away that proviso from one state but keeping it in others?
Because that is a proviso which mention only it applicable to J&K, because it speaks of the Constituent Assembly of J&K. It has nothing to do with any other. There's no proviso applicable to every other. It's a Constituent Assembly of J&K. That's all. Yeah.
Can I ask you in the end if you believe the last legal word has been spoken on this, given that the presidential notification was not part of today's verdict and the judges specifically said that this had not been challenged, the president's power to do this?
No. It was the proclamation of emergency which was not challenged. That is what the court says. Sorry. It doesn't say so.
Presidential rule.
That is the proclamation. You are mixing it up with the presidential proclamation, governor's proclamation of emergency, of declaration. That's a separate proclamation. That has nothing to do with this.
So do you believe the last legal word on this has been spoken, Mr. Nariman?
I don't know. That you are better find out. I just give you what my view is. That's all. At the moment, until this is amended or set aside or whatever it is by the court itself, we have no authority to say this is wrong. That's my view. I don't accept this view. I can't go on television and say this judgment is wrong. So the judges have to answer me. They'd have no business. They say, I don't give a damn for what Nariman says.
I'm sure they give a damn for what you say, but if I may conclude this conversation by saying you will not disagree with the verdict, but you will say that before this verdict, you believe that the procedure was not followed properly because it was done by a presidential notification. That's how the ball was settled.
And it's a substantive procedure. It's not just procedural. It's a substantive provision. Remember, clause 3 is hedged in by the proviso. The president is not given the power himself. It is given only if it says shall be necessary, only if the Constituent Assembly of the state so decides. Now, there is no Constituent Assembly, agreed. There is no Constitution of Jammu Kashmir, that's gone, agreed. Therefore, this proviso has still remained. It's in the book. You have to remove it, therefore, first, before you do anything else. So you remove the proviso, then everything falls into place.
But of course, what you're saying is in contradiction to what the judges thought today.
Beg your pardon? Yes, that's correct. That's correct. I don't know whether that was argued, not argued, etc. That you better ask the people who argued it.
Are you disappointed with the verdict?
No, I'm not. Why should I be disappointed? I am not a Kashmiri or a non-Kashmiri, etc. I'm a citizen of the country. I have to accept the verdict. That's my point. As a lawyer, I have to accept it. I mean, that's a constitutional thing. It's binding on you also, Barkha. Article 141 expressly says so. It's binding on all of us. This is our constitution. So we can't balk at it and say these judges are wrong, these judges are right, etc., etc. That's not our business. We have no authority to say that. So we have to be very careful what we say.
Yes, of course. We don't want to be in contempt of court, but I think what
I'm not bothered about contempt. There's no contempt if I said the judgment is wrong. There is no contempt. But I don't wish to say the judgment is wrong because I think that's not part of the duty of a lawyer to say that a judgment is wrong. If the lawyer is advising other people who are non-lawyers on something that is concerned with the Constitution, he has only to say that this was my view before the court decided this question.
Can I say, at least correct me if I'm wrong, that you will not contest the verdict, but you do believe that the government made a mistake by going the route of the presidential notification when it sought to bring this change?
Yes, correct. Absolutely correct. Because for two reasons, as I told you, that they had to first remove the proviso to Article 370, Clause 3, which they had not removed. And that could only be by a constitutional amendment. And the fact that this is a temporary provision or not a temporary provision makes no difference because it says any provision. Article 368 says any provision can be deleted or added to or subtracted from, etc. That's all.
Got it, Mr. Nariman. That's a lot to think about, even though the verdict is done and dusted. I think your words carry a lot of weight and it will generate a fair amount of interest. So thank you for talking to us.
No. Thank you, Barkha. Excellent.
Thank you, sir. Take care and thank you for explaining it so patiently to me. I'm sorry I was being a bit slow today and it was confusing. Thank you for explaining it so patiently.
No, please. No, not at all.
Thank you, sir. Thank you, sir. Mojo Story has always made a commitment to its viewers to go to where the story is. And as you can see here, we are at the epicenter of the Israel war on Gaza. We are right at the front line, about 1 mile from the Gaza Strip, as the Israeli military gets ready with its tanks and its gunners to begin its final frontal assault that will take troops into Gaza. As we said, we are not like other organizations. We believe in giving you all sides of the story objectively and as much as possible from the ground. And that's exactly what we're doing here, covering the biggest global story today from the epicenter of the war zone. So please, we need your support. Support us, become a Mojo member, subscribe to us, spread the word, and thank you for your support.